We're now going to spend some time talking about how the United States Supreme Court works. And to give you a better understanding of the process and structure of the court, we're going to walk through a specific U.S. Supreme Court case. The court case that we're going to use is the United States v. Jones from the 2012 session. Mr. Jones was a nightclub owner who was convicted on drug charges. Law enforcement had used a variety of techniques to link him to his co-conspirators in the case, including information gathered from a GPS device that was placed on Jones's Jeep. Unfortunately, law enforcement did not have a valid warrant to place the device on the car. Law enforcement had used other evidence to obtain a warrant to place a GPS device on Jones's car within 12 days within the limits of Washington, D.C. However, law enforcement didn't get around to putting the GPS device on until after the 12-day window, and they placed the GPS device on his car while his car was outside of D.C. Thus, the warrant was not valid. Jones was arrested in 2005, convicted in early 2008. He was found guilty of conspiracy to distribute, possession with intent to distribute, and he was sentenced to life in prison. If you take a moment to look at the timeline here, you'll see that getting into the Supreme Court can be a very long process. Jones was originally arrested in 2005, but it wasn't until January of 2012 that the Supreme Court made their ruling. There are 6 key steps to the U.S. Supreme Court's decision-making process that I want you to be familiar with. Step 1 is asking the court to look at your case, and this is what you do in a petition for a writ of certiorari. Once you officially make the request, you file your cert. Your cert goes into the certiorari pool, and the justices meet in person to discuss which cases they would like to take. Once the justices have agreed to take on your case, each side is allowed to submit a brief. And a brief is simply the legal arguments for why the court should decide in your favor. In this case, both Jones and the United States government submitted a series of briefs. Once the justices have had the time to review the briefs from both sides, they schedule oral arguments. In oral arguments, both sides have the opportunity to stand in front of the justices and make their arguments. After oral arguments, the justices meet once more in conference, where they discuss the case, the briefs, and they vote. They make a decision. After the conference, the justices go back to their chambers and begin drafting their opinions. And these opinions are the things that really matter. Opinions are where the United States Supreme Court justices say which side wins and explains exactly why. The U.S. v. Jones case centers around the Fourth Amendment to the U.S. Constitution. The full text is right here in front of you. There are a couple things for you to keep in mind. One is that the Fourth Amendment protects you against unreasonable search and seizure. If the police are going to go through your things, collect information, they need to have probable cause and a valid warrant. And this is the key to the U.S. v. Jones case. There are 2 key questions at play in the U.S. v. Jones case, and the first is about GPS monitoring itself, and asks, does the warrantless use of GPS tracking device to track a vehicle on public streets violate the Fourth Amendment? The second key question here is, does the government violate the Fourth Amendment by attaching a GPS device without a valid warrant? And you'll see in a few minutes that the court treats these 2 questions a bit differently. After the court agreed to take on the U.S. v. Jones case, both sides submitted what are known as merit briefs. And these merit briefs are where both sides lay out the legal argument for why they are right. First up is the petitioner, the U.S. government. And below you see here a basic outline of the main arguments that the government is making. The government says GPS tracking is not actually a search under the Fourth Amendment. Second, the government argues that you have no expectation of privacy on public roads. After all, if you're walking down the street, you don't have any public expectation of privacy. Third, the government argues that the GPS device did not interfere with the owner's use or possession of the vehicle, thus it shouldn't be a problem. And then the government gets creative, and they make a second argument. They say even if what they did constitutes a search and seizure, GPS tracking is reasonable under the Fourth Amendment and no warrant is needed. After the petitioner files their merit brief with the court, the opposite side gets to respond. So we have the argument here for the respondent. In this case, this is Jones' attorneys. Jones's attorneys argued that the government installation and use of the GPS device is a search and seizure under the Fourth Amendment. Second, they make a big deal about the fact that Jones's property was physically violated. Third, they argue that information about a person's movements is uniquely private and thus should be considered a search and seizure under the Fourth Amendment. And finally, they address the government's second argument, and they say yes, using a GPS device is a search and seizure and a warrant is needed. After Jones's attorneys filed their merit brief, the government got one more shot. And they reiterated their original arguments. They argued even if GPS tracking is search and seizure, a warrant is not needed. And they say GPS tracking constitutes only a limited intrusion, if any, on privacy interests, and thus we should not be overly concerned. After the justices reviewed the merit briefs from both sides, they scheduled oral arguments. And oral arguments in front of the U.S. Supreme Court are unique in the federal government. What happens is each side is invited to come into the court and they stand up and they have 30 minutes to talk. So the petitioner, the Solicitor General for the United States government, stands up and starts making his argument. Now you can imagine for an attorney, for a prosecutor, this is probably the highlight of their career, being able to argue a case in front of the U.S. Supreme Court. And you would imagine that they would spend a great deal of time preparing exactly what they're going to say. What's interesting is that in most cases, the attorneys for both sides don't actually get to speak that much. What generally happens is once they get up and they begin speaking, one of the justices will interrupt with a question or a comment. So that 30 minutes you're allotted, you may very well not speak that long. Oral arguments are over in an hour. They're very brief. The justices have already read all the merit briefs and all the amicus curiae briefs, so they have a very good understanding of the case. What is also interesting about oral arguments in front of the United States Supreme Court is that there is no video allowed, no photographs, no cameras in the courtroom. There is audio, however. If you go to the U.S. Supreme Court's website, you can download audio files and listen to the oral arguments in any case you're interested in. After oral arguments are done, the justices regroup and they meet in a closed conference. When I say closed conference, what I mean is the 9 justices sit around a conference table in a room. The doors are closed, the windows are closed. There are no record keepers, there are no assistants, no law clerks. It's just the 9 individual justices. They begin with the most senior justice, and they work their way down to the newest justice. And they speak. They share their thoughts and their opinions on the case. Then they vote, and they begin with the most junior member of the court and work their way up to the Chief Justice. After the justices vote, it is time to write opinions. And there are 3 main kinds of opinions I want you to be familiar with. And the first is the majority opinion. This is the official opinion of the court. One of the justices in the majority is assigned to write this opinion, and they write for the court. They explain what the decision of the court is and why they decided the way they did. The minority, those justices voting against the court's decision, that is, those who disagree with the court's official decision, write dissenting opinions, where they say that they think the court made the wrong decision and then they explain why. And finally, there are concurring opinions. Sometimes a justice will agree with part of a majority or dissenting opinion, but have something else to say. And in this case, they will write a concurrent opinion. Well, they will say, I agree with the majority in parts 1, 2, and 3, but for different reasons. In the U.S. v. Jones case, we have a 9-0 decision. That is, all 9 justices agreed with the outcome. And Justice Scalia was assigned to write the majority opinion. This was joined in full by Roberts, Thomas, and Kennedy. And what this means is Scalia wrote the opinion of the court, and Roberts, Thomas, and Kennedy agreed with both the decision and the reasons Scalia gave. Now, Justice Sotomayor wrote a concurring opinion. And here she said that she agreed with the outcome of the court, but she had different reasons and additional concerns that she wanted to express. Justice Alito wrote a different concurring opinion. And again, Alito agreed with the outcome of the case, but had different reasons and concerns. And his concurring opinion was joined by Justices Ginsburg, Breyer, and Kagan. This all brings us to the question of who cares? What impact is this case going to have on us in the future? And there are really two key impacts we should be keeping our eyes on. One is the increased burden on law enforcement. If law enforcement wants to attach a GPS tracking device to a vehicle, they are required to obtain a valid warrant. If they do not obtain a valid warrant, the evidence cannot be used in court. The second key impact of Jones is likely related to how the justices wrote the opinion. Scalia's majority opinion, that is the one that matters as far as precedent goes, is a very narrow decision. And the court ruled that it was the physical trespassing, that is, the fact that the government had an officer stick his hand in the undercarriage of Jones's Jeep and attach a GPS tracking device. And it's this physical trespassing onto private property that made it illegal, that made it a search and seizure without a warrant. What this means is that the U.S. v. Jones decision does not apply to GPS devices that already exist. So if your car or your smartphone has a GPS tracking device on it, this case does not say that the law enforcement needs a warrant to track you. Something to keep in mind.